Hello students, my name is Abhishek Sudhir. I am an assistant professor at the Jindal Global Law School. Welcome to EPG Pathshala. Today we'll be looking at Module 12, Right to Life under the Constitution of India, Part 2. Much of the development of the right to life under the Constitution of India is down to the creative brilliance of the Supreme Court of India. Through a series of activist decisions, the Supreme Court has expanded the right to life to include the right to die, albeit in a limited sphere. It's also expanded the scope to include the right to health and social security. Not only have they given the word life an expansive interpretation, an expansive meaning, they've also interpreted the words liberty in a very wide and expansive manner. This module will give you, the student, an overview of how and why the Supreme Court has given the right to life and personal liberty new meaning. The learning outcomes. The purpose of this module is to give you, the student, an overview of the constitutionally recognized components of an individual's right to life, and also to help you, the student, understand the manner in which the scope of the right to life has been expanded by judicial interpretation. Quickly, let's look at the text of Article 21. No person shall be deprived of his life or personal liberty except according to procedure established by law. Now let's come to how the Supreme Court has interpreted Article 21. Procedure established by law. This expression was borrowed from Article 31 of the Japanese Constitution, and this expression was interpreted in the very famous case of A.K. Gopalan versus State of Madras, way back in 1951. The petitioner, A.K. Gopalan, was a tall leader of the Communist Party. He was detained under the Preventive Detention Act of 1950, and he contended that the term law in Article 21 should be understood as signifying the universal principles of natural justice. Not only could somebody not be deprived of their right to life and personal liberty, but they could not be deprived of it unless the procedure was based on the principles of natural justice. Does this mean principles of natural justice? It must be based on certain principles, on certain rights that human beings have that are inalienable. A.K. Gopalan, therefore, argued that a law which did not incorporate the principles of natural justice could not be valid under Article 21. And he went on to state that the procedure established by law did not mean any procedure. It meant that that procedure must be just, fair, reasonable, must be due procedure, due process of law, essentially, was what he was trying to say. So what A.K. Gopalan is trying to say here is that just because a law is passed by Parliament doesn't mean it is procedure established by law. That law must meet the stringent test of being just, fair and reasonable, and should be in accordance with the principles of natural justice. The Supreme Court back in 1951 was a very minimalist court. It was a court that had just come into existence and was very wary of being activist. The court rejected Mr. Gopalan's contention and referred to the discussions in the Constituent Assembly and said that the framers deliberately adopted the expression procedure established by law, as it was far more specific. The majority of the Supreme Court thus held that the expression simply meant procedure prescribed by the law, as long as a law was passed by Parliament, and that law essentially provided for situations where individuals could be deprived of their right to life and personal liberty. The Supreme Court would not go into the justness or reasonableness or fairness of that law. The effect of the A.K. Gopalan decision was that Article 21 only protected persons from arbitrary executive action, but did not apply to laws passed by the legislature as long as the procedure of Parliament was followed. All of this changed in the famous case of Menaka Gandhi versus Union of India, where the Supreme Court overruled A.K. Gopalan and held that in order to comply with the mandate of Article 21, the mere prescription of some kind of procedure was not enough. The procedure must be just, the procedure must be fair, the procedure must be reasonable, and not arbitrary, fanciful, or oppressive. Now, in the landmark case of Olga Tellis, the Supreme Court stated, procedure which is unjust or unfair in the circumstances of case attacks the vice of unreasonableness, thereby attracts the vice of unreasonableness, thereby vitiating the law which prescribes that procedure and consequently the action taken under it. The issue was settled once and for all in the famous case, more recent case rather, of Selvi versus State of Karnataka. And the Supreme Court held that substantive due process, which essentially means a procedure that is just, fair and reasonable, was now a guarantee under the Constitution. Now let's come to the interpretation of the words personal liberty. The expression personal liberty used in Article 21 has also been given a liberal interpretation. It does not mean merely the liberty of the body, the Supreme Court has held. That is, not merely freedom from physical restraints or freedom from confinement within the bounds of a prison. In other words, it not only means freedom for arrest and detention from false imprisonment or wrongful confinement, but it means much more than just physical liberty. The term personal liberty, as the Supreme Court has held, is not used in a narrow sense, but has been used in Article 21 as a compendious term to include within it all those variety of rights of a person which go to make up the personal liberty of a man. In the case of Kharak Singh versus State of Uttar Pradesh, the Supreme Court held as follows. I quote, personal liberty in Article 21 is a compendious term. As a compendious term is to include within itself all of the varieties of rights which go up to make the personal liberty of a man. They went on to state that the unauthorized intrusion into a person's home and the disturbance caused to him thereby violated his right to personal liberty enshrined in Article 21. It does not matter that you enter someone's home and don't arrest them. By just entering their home, without being authorized by law to do so, you are violating that person's personal liberty, their right to privacy within their own home. It's also worth noting that in the case of Satwan Singh versus Assistant Passport Officer, New Delhi, the Supreme Court has included the right to travel abroad as being implicit in the expression personal liberty within the meaning of Article 21. So therefore, the personal liberty includes your liberty to leave the country and travel abroad. Now let's come to some of the components of the right to life under Article 21 of the Constitution of India. We've already examined some of these components in an earlier module. Here we will look at some specific components of the right to life that are at the very cutting edge of legal issues in the 21st century. Perhaps the issue that is really contentious in this day and age is the right to die. With advancements medically, the presence of ventilators, artificial life, and life-prolonging treatments, the right to die is now front and center of the national consciousness in India. Section 309 of the Indian Penal Code 1860 punishes a person for attempting to commit suicide. The constitutionality of Section 309 was considered for the very first time before the Bombay High Court in State of Maharashtra versus Maruti Shripati Dubal. In this case, the Bombay High Court held that the right to life guaranteed under Article 21 includes the right to die, and the Bombay High Court struck down 390 of the IPC as unconstitutional. Therefore, not only do you have the right not to be deprived of your life, you also have the right to be allowed to take your own life if you choose to, was what the Bombay High Court said. This interpretation was overruled by the Supreme Court of India and held that initially, a division bench of the Supreme Court in P. Ratnam versus Union of India supported the decision of the Bombay High Court and held that under Article 21, the right to life also included the right to die and struck down Section 309 as being unconstitutional. However, a 5-judge bench of the Supreme Court in Gyan Kaur versus State of Punjab overruled the division bench's decision and put an end to the controversy. They ruled that Section 309 of the IPC, which essentially criminalized anybody who attempted to commit suicide, was neither violative of Article 21 or Article 24, Article 14 rather, right to equality. The court held that the right to life under Article 21 did not include the right to die. However, in December 2014, all of this changed. 22 Indian states decided to repeal Section 309 of the Indian Penal Code. Thus, the issue of whether the right to die is implicit in the right to life under Article 21 now needs to be re-examined by the Supreme Court. The Union government has also indicated that it will carry through a repeal of Section 309 of the IPC. This is to be welcomed. No matter where you stand on the issue, it appears that those who attempt to commit suicide are clearly individuals who are troubled. They should be given medical help rather than being punished further. Seems to be the rationale behind the decision of most of the state governments that have decided to repeal Section 309. Now let's come to the contentious issue of euthanasia. Passive euthanasia is legal in India. It is worth stating at the outset that there is absolutely no law governing euthanasia in India. On 7th March 2011, the Supreme Court of India legalized passive euthanasia by means of withdrawal of life support to patients in a permanent vegetative state. The decision was made as part of the verdict in a case involving Aruna Shanbag, who had been in a vegetative state for 37 years at King Edward Memorial Hospital. Unfortunately, or fortunately, depending on your point of view, in May 2015, Aruna Shanbag finally succumbed. In some 40 years ago, Aruna Shanbag was brutally raped by an attendant at the hospital that she worked at. Following the rape, she went into a permanent vegetative state. Those in a permanent vegetative state are not in a coma. However, they have absolutely no awareness of their surroundings. They cannot feel anything. They cannot feel any emotions. They cannot communicate. However, they are awake. All bodily functions can be performed but not voluntarily. They have no control over the passing of urine and stools. Given Aruna Shanbag's plight, an individual by the name of Pinky Virani approached the Supreme Court in 2011. She said that the nurses who had been caring for Aruna Shanbag for almost 4 decades at the King Edward Memorial Hospital should be ordered by the Supreme Court to stop feeding her, essentially letting her die. The court rejected active euthanasia by means of a lethal injection. It said that under no circumstances should Shanbag be given a lethal injection whereby a positive act would result in her death. That would amount to murder and would be punishable. In the absence of a law regulating euthanasia in India, the court stated that its decision in Aruna Shanbag would become the law of the land until the Indian Parliament enacted a suitable law. Active euthanasia, as I've just mentioned, is still illegal in India. While rejecting Pinky Virani's plea for Aruna Shanbag to be allowed to die, the court laid down guidelines for passive euthanasia. In Shanbag's case, what the court found essentially was that Pinky Virani did not have the capacity, the competency to make that decision on behalf of Aruna Shanbag. They believed that Pinky Virani did not have enough of a nexus with Aruna Shanbag. She was not a relative of Aruna Shanbag's. Unfortunately, none of Aruna Shanbag's relatives also were interested in her plight. Therefore, the court held that it was the nurses, the medical staff at the KEM, through the dean of the KEM hospital, who was Aruna Shanbag's next friend. What this essentially means is that it was up to the dean of the KEM hospital to take a decision as to whether they should stop feeding Aruna Shanbag. If they decided that they would stop feeding her, the court held that that would be legal. According to the guidelines, passive euthanasia involves the withdrawing of treatment of food that would allow the patient to live. So the Supreme Court held that it was the dean of the KM hospital who could take that decision, thereby legalizing passive euthanasia. The guidelines also state that anybody who faced Aruna Shanbag's plight in the future can be allowed to die, provided that decision is taken by their relatives and is approved by a 3-member panel of doctors. Their decision subsequently has to be further ratified by the concerned High Court with jurisdiction. So essentially, the judiciary gets the final say on the treatment that should be given to patients who are in a permanent vegetative state and whether they should be allowed to die. However, in making that decision, the concerned High Court will take into account the views of the doctors and the relatives. As India has no law on euthanasia, the Supreme Court's guidelines in Aruna Shanbag's case are law until and unless Parliament passes legislation. Therefore, we cannot emphatically state at this stage that the right to die is part of the right to life. However, passive euthanasia is now legal in India. Now let's come to another controversial issue, the death penalty. The Supreme Court addressed the question of the constitutionality of the death penalty for the first time in Jagmohan Singh versus State of Uttar Pradesh. In that case, the court concluded that the death penalty was constitutionally permissible, provided It was imposed after a fair trial pursuant to a procedure established by law. In rendering its decision, the court also emphasized that the discretionary judgments of the trial courts were subject to appellate review. In Bachchan Singh, the Supreme Court held that Article 21 recognized the right of the state to deprive a person of his life. There was no absolute bar on the deprivation by the state of an individual's life. If there was such a bar, an absolute bar on the state depriving an individual of his life, then the death penalty would be per se unconstitutional. What the Supreme Court held in Bachchan Singh was that the state could deprive the individual of his life in accordance with a just, fair, and reasonable procedure established by valid law. What is that valid law in India? That valid law is Section 302 of the Indian Penal Code, which essentially prescribes the death penalty for murder. There are also other sections that prescribe the death penalty for certain offences. In Bachchan Singh, it was held that the death penalty awarded under Section 302 of the IPC did not violate any basic features of the Constitution, that the law was just, fair, and reasonable. The law essentially meant that an individual would first be tried by a court of sessions, the trial court. If the court of sessions was to sentence that individual to death, that death sentence would have to be confirmed by the concerned high court. Then the individual would also have the right to appeal to the Supreme Court for a review of the decision of the High Court's decision, and further, the individual would also have the right to file a mercy petition with the President of India, although this is not governed by Section 302 of the Indian Penal Code, but by Article 72 of the Constitution of India, which grants the President the discretionary power to grant a pardon and commute a sentence of death to one of life. We will come back to this in a bit. For now, let us look at the case of Alauddin Mia versus State of Bihar, where the Supreme Court referred to their earlier pronouncements and held that the death sentence should be reserved for the rarest cases, the rarest of the rare, cases which are of an exceptional nature. Most recently, the death penalty was imposed on the four of the five gang rapists in the Nirbhaya case. There, the crime was of a brutal nature. The use of devices such as rods and the intestines of the victim were pulled out. It was a crime of a gruesome nature, a crime of so gruesome that it deserved those who were convicted deserved the death penalty. It was a case that came under the definition of rarest of the rare. In T.V. Vatiswaram versus State of Tamil Nadu, the Supreme Court also held that a delay in execution of death sentence exceeding 2 years would be a sufficient ground to invoke a protection under Article 21, and the death sentence should be commuted to life in prison. The cause of the delay, the court held, was immaterial. In fact, the accused himself may be the cause of the delay. However, a more concrete, a more emphatic elucidation of the law came in the recent case of Shatrughan Chauhan versus Union of India. A 5-judge bench of the Supreme Court, led by Chief Justice Sadashivam, held that an inordinate delay, an unjustifiable, inexplicable delay in disposing of the mercy petition filed by a prisoner on death row was a ground for commuting a death sentence to one of life in prison. Essentially, they said that an individual should not face the plight of waiting for years and years on end to discover his or her fate on whether he or she shall be executed by the state. In Shatrughan Chauhan, the Supreme Court commuted the death sentence of convicts to one of life because of an inordinate delay on behalf of the President of India in disposing of their mercy petition. Essentially, what the court said, that you cannot leave this convict on death row hanging for years on end, going to sleep every night, not knowing if tomorrow will be the day that they will be finally executed. Therefore, it is incumbent upon the state to expedite the process of the mercy petition, of the execution, and a decision should be made as quickly as possible. If not, then on the ground of a violation of Article 21, right to life, the court has the power to commute that death sentence, convert that death sentence into one of life in prison. In Dina versus Union of India, the constitutional validity of the death sentence was by hanging was challenged. In many countries around the world, the that still have the death sentence, still execute people, still have capital punishment. Hanging is not followed. There, for example, in the United States, people now use lethal injection. The states in the United States use lethal injection to execute convicts. They believe that this is a more humane way. In the case of Dina, the petitioner challenged the validity of the death sentence by hanging, as the petitioner argued it was a barbarous, inhumane, and degrading method of execution, and therefore violative of Article 21. The Supreme Court, referring to the report of the UK Royal Commission 1949, the opinion of the Director General of Health Services of India, the 35th report of the Law Commission of India, and the opinion of the prison advisors and forensic medicine experts, the court held that death by hanging was the best and least painful method of carrying out the death penalty. Death by hanging was the best and least painful method, is what they said, and thus not violative of Article 21. This is something that you might want to think about carefully. And if you're interested in this area, it would be an area that you could even consider researching on. Is hanging by the neck really the most humane method? Some would say it is lethal injection. Now let's come to the right to social security and protection of family. The age-old question, is India a welfare state? Certainly, if you look at India's constitution and the directive principles of state policy, part 4 of the constitution, one can safely conclude that India is a welfare state, a state that believes that it must, where possible, take care of its most vulnerable citizens who are unable to fend for themselves. The right to life guaranteed under Article 21, the Supreme Court has held, includes within its ambit the right to social security and protection of the family, the right to free medical treatment, for example. Socio-economic rights, as they are known, have been said to be basic aspirations for a meaningful right to life, and that the right to social security and protection of family are integral to the right to life. In the interesting case of the Life Insurance Corporation of India versus Consumer Education and Research Center, the Supreme Court has held that the right to life and livelihood includes the right to life insurance policies of the Life Insurance Corporation of India. And they have stated that it must be within the paying capacity and means of the insured. Essentially, the LIC being a company that is run by the state, an insurance company run by the state, their policies, the premiums should be very affordable that an ordinary common citizen of this country can have access to. Thus, the right to social security and protection of family is included in the right to life. Supreme Court has also held that the right to health and medical aid and a duty to preserve life is also within the ambit of Article 21. Many of us growing up are told sometimes not to come to the aid of people on the road that we see who have been involved in an accident. It is unfortunate, and this is something that the Supreme Court has sought to address. The right to life guaranteed under Article 21, the Supreme Court has held, includes within its ambit the right to health and medical care. In the significant case of Paramananda Katara versus Union of India, it was held that it is the professional obligation of all doctors, government or private, to extend medical aid to the injured immediately. The Supreme Court held that they must, the doctors, by virtue of the Hippocratic Oath and the commitments under Article 21, extend medical aid without legal formalities to be complied with. The police. A doctor essentially cannot refuse to treat an individual who right before his eyes is battling for life and cannot take recourse to the law. In such a situation, the right to health, the right to treatment, emergency treatment, the right to medical aid, and the duty to preserve life extends to both government and private doctors. Article 21 casts the obligation on the state to preserve life. It is the obligation of those who are in charge of the health of the community to preserve life so that the innocent may be protected and the guilty may be punished. The Supreme Court has emphatically stated that no law or state action can intervene to delay and discharge this paramount obligation of the members of the medical profession. It is no longer a defense for someone to say that the police must be called, legal formalities must be complied with before treating a particular individual who is battling for his or her life. Recently, in the case of Poonam Sharma versus Union of India, the court held that it is the duty of the doctor to aid the injured and not to delay the same. Any delay, any wait for the police before treatment is taken to be a violation of one's fundamental right to life, one's fundamental right to health and treatment and emergency medical aid under Article 21. Now let's come to the mechanisms evolved by the Supreme Court of India to punish the state for violations of the right to life. In the famous case of Rudolf Shah versus State of Bihar, the Supreme Court has held that the court, they have the power to award monetary compensation in appropriate cases where there has been a violation of the fundamental right under 21. In the unfortunate case of Rudolf Shah, the Supreme Court directed the Bihar government to pay a compensation of Rs 30,000 to Rudolf Shah, who had to remain in jail for a further 14 years after being acquitted, thanks to the negligence of the government officials. It is violations like this, gross violations, that have led the Supreme Court to order that monetary compensation must be paid. The right to life, as we can see, is sacrosanct, and especially when the state by its negligence violates that right, the Supreme Court has come down hard on them in the past and is likely to come down hard on the state in the future. So students, we come to the end of this module on the right to life under the Constitution of India. We have seen that the Supreme Court has played a very activist role in expanding the meaning of the word life and personal liberty under Article 21. Fascinating issues such as passive euthanasia and the legality of the death penalty have been deliberated and decided upon by the Supreme Court of India. The death penalty, some might say, is a barbarous way of ending a human being's life. Should the state have the sanction to end someone's life is an issue that is worth considering. In India, for many years, the state had not executed any individuals. But in the recent past, both Afzal Guru, the prime accused, the key accused convict in the Parliament attack case, and Ajmal Amir Kasab, the gunman in the terrorist who attacked the Taj and Chhatrapati Shivaji Terminus and other targets in Bombay, were both executed. The question is, what purpose does the death penalty serve? Does the death penalty truly act as a deterrent? If it does, perhaps is it worth it? If it does, then perhaps there is a justification for keeping it on. These are issues that the Supreme Court has considered, but the Supreme Court has upheld the constitutionality of the death penalty. As far as euthanasia is concerned, the Supreme Court has very clearly said that the right to life does not include the right to die. However, in the landmark case of Aruna Shanbag, it would appear that the Supreme Court, albeit by implication, is saying that there is a right to die with dignity. And also the repeal of Section 309 of the Indian Penal Code is also further evidence of the fact that Indian society seems to be moving towards an interpretation of the right to life that is radical. The Supreme Court has legalized passive euthanasia by issuing guidelines. To ensure the enforcement of this right, we've seen that the court has also devised the remedy of granting affected persons compensation from the state exchequer. This shows the sacrosanct nature of the right to life. We have also seen that the Supreme Court has expanded the right to life to include the right to social security, the right to protection of family, and has even said the right to life includes access to life insurance policies of the Life Insurance Corporation of India. Irrespective of whether one agrees or not with the activist approach of the Supreme Court, one has to admire their judicial craftsmanship. The Supreme Court has essentially stepped in to the shoes that of the state. The state, unfortunately, in 2015, still has not kept a constitutional promise. The constitutional promise in the directive principles of state policy was that all citizens would be given a right to livelihood, that all citizens of this country would have the right to lead a life with dignity. All citizens of this country would have the right to lead a right to have a quality of life, a good standard of life, a life that would be fulfilling in all its aspects. However, the state has failed. One could argue that the state has failed because simply there is no money. And it is all well and good for the Supreme Court to say that the right to life includes all of this, the right to life includes the right to having a good life. But where is the money? But at the same time, one has to state that the aspirational value, the aspirations laid out in the Supreme Court judgments must be welcomed. And the right to life, the right to aspire to a better life, is at the core of Article 21, according to the Supreme Court of India.